All right, let's talk about a document that's pretty much the hidden bedrock of almost every major construction project in the U.S., the AIA A21. Now, if you work in the built world, you've definitely heard of it, but do you really know how it works? And more importantly, what the latest version means for your projects? We're going to find out. And yeah, that's a serious question. I mean, think about it. You've got hundreds of people, dozens of different companies, and millions, sometimes billions of dollars all converging on one single site. The complexity is just guaranteed. The potential for misunderstandings, for disputes, for just outright chaos is absolutely massive. So how do you manage all that? Well, the answer is this document right here, the A201. Honestly, the best way to think about it is as the project's official rulebook. It isn't the main agreement that says, build this for X number of dollars. Instead, it's the set of general conditions that dictates how everybody is going to work together. And that's exactly why we call it the keystone. It locks all the other contractual pieces firmly in place. Okay, so let's really unpack that keystone idea, because it's so important. What actually happens on a project that doesn't have this kind of standardized foundation? This is what happens. We are talking about the potential for, and this is a direct quote, mass confusion and chaos. And that's not an exaggeration. Just try to imagine an owner who has one set of rules for their architect, but a completely different set for their contractor. And then that contractor has different agreements with every single one of their subs. It would be an absolute nightmare of gaps and overlaps and who's responsible for what. The A201 solves this with a really simple but powerful idea. It's a single rulebook that everyone just agrees to use. So instead of rewriting the rules for every single agreement, the owner-architect contract, the owner-contractor contract, and even the subcontractor agreements all just say, hey, we agree to follow the rules in the A201. And just like that, one document creates a common, stable language for the entire project. It's pretty brilliant. Now let's get to know the three main players whose roles are defined by this document. The A201 is really all about creating a balanced, clear relationship between the owner, the contractor, and the architect. So you can see each player has a very distinct lane. The owner, they fund the whole thing. The contractor, they manage the physical construction, the boots on the ground. And the architect designs the project and, this part is crucial, administers the contract as it's being built. But here's the most interesting part of this whole relationship. Notice how the architect contracts with the owner, but not directly with the contractor. That unique position allows them to act as a more impartial initial decision maker when disputes pop up, which helps keep the project moving forward. The A201 isn't static. It gets updated about every 10 years to keep up with the industry. So, let's dig into the 2017 edition to see the most significant changes. They tell us a lot about where modern construction is headed. And we're not just talking about minor tweaks here. The 2017 revision reflects some major shifts in how projects get managed, especially when it comes to technology, risk, and just basic communication. This thing was updated based on feedback from everyone: owners, architects, contractors, lawyers, even insurance agents. It's a real snapshot of the industry. Okay, one huge theme in the 2017 update is finally catching up with the digital age. For starters, official notice can now be given by email. That is a massive change for day-to-day project communication. The update also requires teams to establish digital protocols right up front, especially for complex stuff like building information models, or BIM. This is all about preventing that digital chaos that happens when one team's software can't talk to another's. Now for what might be one of the most talked about changes. Imagine a contractor is digging and hits an unexpected patch of solid rock. In the past, they had 21 days to formally report that concealed condition. Well, in the 2017 version, that window has been slashed down to just 14 days. That is a massive shift. It puts so much pressure on contractors to identify, document, and report surprises on site with incredible speed, or they risk losing their right to a claim entirely. The 2017 update also rebalances project risk, especially around insurance. First, it makes it super clear that the owner and architect have to be named as additional insurance on the contractor's main liability policy. And to simplify things, all those complex insurance details were moved into their own separate exhibit, which makes it much easier for lawyers and insurance brokers to manage. And here's a big win for contractors. There's now a built-in termination fee. So if an owner cancels the project just for their own convenience, the contractor is guaranteed a pre-agreed payment. That provides some much-needed financial certainty. So we have the rules and we know who the players are. But what happens when things go wrong? Because they do. This is where the A21's dispute resolution process comes in. Think of it as the project's built-in safety net. I mean, let's say the contractor and owner totally disagree about whether something is extra work. Or maybe there's a big dispute about a delay. Instead of everybody immediately running to their lawyers and filing lawsuits, the A201 lays out a very specific path that everyone must follow. And this is not about rushing to court. It's a three-step process designed to resolve issues as efficiently as possible. So, step 1. The claim goes to an initial decision maker, or IDM, who is often the architect, for a fast ruling just to keep the project from grinding to a halt. If either party disagrees, they can't sue yet. They have to go to step 2, mandatory mediation, where a neutral third party tries to help them find a compromise. And only if that fails can they move to step 3, a final, binding resolution like arbitration. The whole system is designed to keep disputes out of the courtroom if at all possible.
And this really brings us full circle, doesn't it? Every single rule, every role, every process we've talked about, it's all built for one purpose: to replace that potential for chaos with a clear, predictable, and fair framework. It's like the architectural plan for the business of construction itself.
So look, the A201 provides an absolutely incredible legal framework. It truly sets the stage for success. But it's not a magic wand. A contract, no matter how perfectly written it is, can't force people to collaborate or to trust each other. The keystone document holds the arch together for sure, but it's the people on the ground who make sure it actually stands strong. Which kind of leaves us with the final question. Your contracts are in order, but is your communication? Thanks.